Picture this. It's Sunday, the kids are in jerseys, the couch is halfway to a shrine, and then one parent gets called out of town. Instead of a meltdown, someone pulls out a short clause they both signed, a swap plan, a backup caregiver, and a quick phone call. Game on. Kids keep their ritual. No court scramble, no missed memories. Welcome to Danni's Den. I'm Danni, and today we'll talk about how a few thoughtful pages can protect the routines your kids depend on. Let's chat. In the next 10 minutes, I want to give you straight talk. What prenups and postnups really do, what they can't do when it comes to kids, how to write plain language clauses for holidays and game days, and a short checklist for meeting a lawyer so you leave with clarity, not confusion. First, quick definitions. A prenup is an agreement signed before you marry. A postnup is the same kind of agreement, but you sign it after you're married. Both can sort out property, debts, and financial expectations if the relationship ends. But courts decide custody and child support based on the child's best interests, not because a contract says so. That's important. Contracts can help shape agreements, but they don't override a judge's duty to the child.
Curious. Want to bust a couple of myths quickly?
Myth 1. Prenups are only for rich people. Nope, they're for anyone who wants clarity. Who pays what, who keeps what, and who handles debts if things change. Myth 2. A prenup decides custody forever. Also not true. What it can do is record routines you both value, a parenting calendar, holiday plans, or a backup kill plan, which can make settlement smoother. But a court still has final say. So what can you include that actually helps protect parenting rhythms? Think forward-looking, practical items. Guardianship designations for emergencies, education fund commitments, a parenting calendar template that shows weekdays, weekends, holidays, and your game day routines. A clause requiring mediation before litigation. Those are realistic, useful, and family-friendly. Want a red flag? Anything that tries to waive child support, lock in custody forever, or hide assets, courts will strike those parts down. So use these documents to preserve expectations and routines, not to strip protections from the child. All right. How do you actually bring this up without making your partner feel like they're signing away the romance? Start with values. Say something like, I love our Sundays. Can we find a way to protect that for the kids no matter what? Framing it around care, not control, changes the tone entirely. Offer to meet counsel together. Suggest breaks if anyone feels pressured. Insist on independent lawyers for both of you. That's a best practice and prevents later claims of coercion. Personal note, and why I care about rituals. I grew up in a house where Saturdays were sacred. Those routines steadied us when things were messy. Protecting rhythms isn't legalism. It's protecting children's predictability. Let's make this tangible. What might a short game day clause sound like? Keep it bullet simple. Example. Parent A has first right to Sunday afternoon game attendance on even-numbered weeks. Parent B on odd-numbered weeks. In case of conflict, parents must attempt a 72-hour swap or use the designated backup caregiver listed below. Add travel logistics, who pays for a last-minute ticket, or whether a televisit is acceptable if physical attendance isn't possible. Plain language makes these plans usable in a hurry. I want to pause here for a real quick, true micro-story. I once spoke with a dad who flew across state lines chasing a court order because there was no plan. The kids missed the whole game while adults scrambled. Painful. Avoidable. That's exactly the scramble these clauses prevent. A few legal safety notes. Don't sign anything under pressure. Don't skip independent counsel. And don't accept wildly one-sided terms. If safety is a concern, for example, if a partner has a criminal history that affects caregiving, bring an attorney in early. The child's safety comes first. Okay, here's a short checklist for your attorney visit. Bring recent pay stubs or tax returns, a list of assets and debts, any custody or support orders you already have, and a calendar of the family rituals you want protected.
Ask these questions. Will these clauses hold up in my state? Will a court likely treat parenting-related provisions as enforceable? Do you recommend independent counsel for my partner? How will these clauses affect child support math?
If you found this useful, do me a favor. Subscribe now so you don't miss future episodes that mix law with real family life. I'll drop a quick checklist and a mellow track next to help the conversation land easier.
It'll feel awkward at first to bring up contracts when you're in love. Say it kindly. And remember, this is about protecting kindness and predictability for your kids, not predicting failure.
Quick recap. Prenups and postnups give financial clarity and can carry family-friendly clauses that preserve routines. They don't replace a court's role on custody or support. Use plain language addenda for rituals. Insist on independent counsel. Bring the documents on my checklist. And prioritize safety if there are complicating histories. I'll leave you with a short, low-pressure R&B/hip-hop pick from the late 90s, early 2000s to ease the ride home. Keep the volume easy and let the music be a soft reminder. Tough talks don't have to be lonely.
Thanks for listening to Danny's Den. If you have a specific legal issue and want to see if I can help, send me a direct message or email Danielle@thelegalassistancecenter.net to book a free 30-minute consultation. You can also drop a comment below. Let's chat.